Happy Friday. Happy March. I hope you people are still loading on. I'll wait 1 second. So it is a spring day out there, right? Usually isn't March supposed to come in like a lion and go out like a lamb? We have it coming in like a lamb. So it's some nice weather out there. Hopefully the sun keeps shining for us. The let's see, let's do dog of the day first, and I'll talk about some of the other stuff. First of all, we got a really nice crowd today. Hi, Donna. I haven't seen Donna. We were talking about you yesterday. So nice day, and we have the dog of the day today is Sadie. Do we have Sadie out there? And Sadie is Bonnie Hendricks' dog. Bonnie Hendricks is from Executive Property Management based out in North Brunswick as well. And Sadie had her party hat on for the entire birthday party she was attending. She was a good dog and did not take her party hat off. So that's Sadie. Thank you very much for Sadie. Very nice. And we're going to go through the usual announcements, right? This is not legal advice, general informational purposes only, educational purposes, no attorney-client privilege, no attorney-client relationship. This is not legal advice. If you want legal advice, you got to go out there and hire a lawyer. Hopefully it's us. But you have to go speak to a lawyer if you want legal advice. Nothing will be kept confidential today. There is no relationship, so we won't keep things confidential. So if you do put something in the chat, keep in mind, don't do something crazy where you're going to breach confidence. So today was this spring, if you will, winter spring has been really a hot time for legislation and legal decisions and so forth. But before we get into the detail of it, for all of you out there who were not government majors or political science majors, I was a business major undergrad, so I was not political science or history or anything like that. So today we're going to talk a little bit about some weird topics that you may not have touched on, and I didn't learn about really, I guess, until I might have forgotten what I had in high school, but I didn't really learn about it really until law school, right? So you have three branches of government. You have the executive branch, the legislative branch, and the judicial branch, or the judiciary. The executive branch, as you all know, if you watch TV every morning where these people scream at each other, they're elected by the people. The legislature is also elected by the people, and they scream at each other sometimes too, not as much as the executive branch, it doesn't seem. But everyone's screaming at everyone on morning TV. And then you have out on the side there, kind of, you don't hear about them as much, although recently you've heard about them a lot, is the judicial branch, not elected. But what we're going to talk about today implicates some of those things, the separation of powers, and the people who founded this country set up the separation of powers for what? For checks and balances, so that one branch of government, especially an unelected branch, doesn't run away with taking control of our entire government system without being answerable to the people. And that's one of the touchstones, the concepts of the case decision we're going to talk about today. So in 2017, everyone remembers this, Radburn. It was pre-COVID. Everyone seemed to be happy. Not everyone was grumpy yet. We didn't go into COVID and everyone lose their minds. But Radburn was passed, and Radburn was passed essentially for two things. Number one, free and fair elections. Number two, association transparency, right? Free and fair elections, association transparency. God bless America, everybody's happy, right? So although there were some problems with the Radburn law that was passed by the legislature, right? That's that branch that was elected we talked about. There's some problems with the law, nothing crazy, but some problems here and there. No piece of legislation is going to be perfect. Then in 2020, we got the Radburn regulations, which were created by an administrative agency, the Department of Community Affairs, not an elected body, not part of the legislature, actually part of the executive branch of government, and not really answerable to the people in any way. So when you have administrative regulations as opposed to law, statutes, they're generally not created by elected officials. They're created by people who are supposed to abide by the letter and the intent of the statute that the legislature passed, but they don't always do that, right? If someone is going to give you a free hand to do whatever you like, there's a tendency in government and administrative agency to do perhaps more than you were permitted to do under the original statute. And that's not to say that these administrative agencies, especially the one talking about today, doesn't have the best of all intentions, but anybody who's ever had a grandmother knows that the road to hell is paved by good intentions, right? I know I was told that by my grandparents, and it is a truth. It's a truism, right? So what happened is in 2017, Radburn passes. In 2020, they adopt the Radburn regulations, and they go into effect in the middle of COVID, right? The Community Association Institute of New Jersey, you all know about that. And I said, wait a second, these regulations, we're aware of them, but they don't seem right. Many of them seem out of step, outside the bounds of the statutory authority that the legislature passed. We think perhaps you either made a mistake, administrative agency, or you just overstepped your bounds, right? You just went too far in these things. So CAI New Jersey, let's see, I want to give the attorneys credit here. So what was it? Dennis Estes and Mr. Patel. Mr. Patel's first name escapes me right now. Oh, Akshar Patel, both from the Greenbaum law firm, on behalf of CAI New Jersey, challenged the regulations. That's great. So they filed a lawsuit, and the court said, wait a second, not too fast. They dismissed the lawsuit and made them go back to the administrative agency and follow a process of challenging the regulations in the administrative law framework. So many of you who we've talked about these regulations for a long time now, you've heard me say, there's this case working its way through the system, but we really don't know where it is. We don't know where it's going to come out. So what happened was things didn't work out. Some changes were made during that administrative process, and we talked about that, I think, several months ago, and we can revisit that someday if you like. But they weren't major ones. And CAI New Jersey, of course, was still unhappy. They went back and said, okay, court, we've exhausted our administrative remedies. We've tried with the administrative process. It hasn't satisfied us. Now we're going to file a lawsuit here. We're going to refile our lawsuit. We're going to challenge these various administrative regs. Basically, 10, 11 of those regs were challenged by CAI New Jersey, and the CAI was successful in three of those challenges, right? So we talked about Radburn. We talked about the Radburn regulations. And then the first successful challenge was mandating that a board seat be reserved for election of affordable units if the affordable unit homeowners held a minority of the units in the community. It basically said if the units that were affordable, low and moderate income houses in your community were a minority of the total number of homes within your community, the association had to reserve a seat for election by those affordable unit owners. And that's what the regulation said. The statute did not say that, however. Okay, so this is a big issue. Mike is with us today, Mike Palulak. And Mike has had two issues this week regarding the very issue of whether that requirement is still in place. And the court struck down that requirement in the regulation. They said, wait a second, you have gone too far. You are legislating on your own there, administrative, and I'm paraphrasing all this stuff, but you've gone too far. You've gone outside the bounds. So I believe that is a very good thing. I don't think that was the intent of the legislature when it passed that law. It wasn't in the legislation. And so for those of you who do have affordable homes within your community, that is not a requirement. The next topic that was stricken was one second. Let's see, mandating affordable board seat. Oh, the next section was the closed meeting vote. So the closed meeting vote. So all of you know, we've talked about this a whole lot. We have open board meetings, and everyone hears me preach about this all the time. In my opinion, as many decisions as humanly possible should be made at open session. I'm a big advocate for transparency. However, the statutes that govern community associations, condominium associations, co-ops, etc., provide exceptions for that, right? So that the associations can deal with business that is inherently private, any matter the disclosure of which would constitute an unwarranted invasion of individual privacy. That's one. Any pending or anticipated litigation or contract negotiation. That's two. Any matters falling within the attorney-client privilege to the extent the confidentiality is required in order for the attorney to exercise his ethical duties as a lawyer. That means us giving you advice, talking back and forth about pending issues. And 4, any matter involving employment, promotion, discipline, or dismissal of a specific officer or employee, right? And those things, generally speaking, even though the Radburn tweaked some of the language here and there, they have had long-standing in the Condominium Act and PREDFA, right? That those 4 exceptions make sense, because how can the association deal with these sensitive matters like employment issues, like contract negotiations, et cetera, like attorney-client privilege, like how are we going to deal with this litigation if you're doing in front of 200 people? Right? Because it's more than likely that one of those 200 people may be involved in the litigation. One of those 200 people may go back to their cousin Bob and say, hey, the snow removal contract there, the bidding is like this, and maybe you should submit a bid and maybe the bid will come in differently. Right? So all those things were reserved for executive session, which makes a lot of sense. And we've talked about handicapped accommodations too. That would be in the realm of inherently private. Okay, so executive sessions. When the 2020 regulations came out, the DCA said, we're going to pass a regulation that says a vote taken at a closed meeting shall not be binding. If the matter requires a binding vote, the vote shall be taken at a subsequent open meeting in a matter that does not disclose any confidence, right? And we've talked about this before. How would that make sense? I make a motion to fire blank. All in favor? Yes, we're all in favor. And as you know, everyone would come up and say, what was that motion about? Oh, we just fired somebody, but I can't tell you. We're negotiating a contract and we have 2 bids and we need them to go back and revise their bid. And we're making a motion for them to go back and revise their bid because they haven't included this and such. You can't operate that way. But that's not really the way the basis for the decision. The court just basically again said, you went too far. That's not what the legislation says. The legislation contemplated association when it used the language dealing with these matters in executive session, that it included voting on these matters, and that makes a lot of sense. It contrasted it to what a lot of people cite as the Sunshine Law, which associations are not subject to the Sunshine Law. The Sunshine Law addresses public governmental bodies, right? Not associations, private communities. Okay, so big difference there. The third thing, which is a bit interesting, is it's not really a big issue for us, but we've talked about it before on First Friday with Fran. There is an issue that is a distinction between when you are doing ballots, proxy ballots and absentee ballots for an election, and whether you're doing proxy ballots and absentee ballots for an amendment. It's not a huge issue for us, but it's something that highlights some of the issues when an administrative body is challenged with coming up with regulations. What was happening prior to Radburn is, and I've seen it, I've had this case myself, where in the election context, proxies were being sent out without absentee ballots. And what was happening is some people in certain communities were going throughout the community and collecting proxies, okay, and then voting those proxies, right? And thereby controlling the entire board. I actually had this at one of my communities, and I wound up threatening to sue the person because they were manipulating the entire association, and really one person was controlling the entire board by collecting proxies from her investor owners, right? She was a realtor. She owned a unit in the community, but she was also a local realtor. And when people would sign with her to manage the rental unit, she would say, by the way, while we're at it, can you give me this proxy? And they would. They're like, I don't care anyway, as long as I get my check every month. So the realtor would take them, and she would more or less, through her proxy control the entire board. So what Radburn Reg did say was, hey, wait a second, what we're going to do, maybe we can't stop that through regulation, but what we're going to say is, if people in an election context are given a proxy, they must also be given an absentee ballot. So people know that even if their proxy goes out, Joe Smith is going to have an absentee ballot and he can submit that. Okay, the regulation adopted by DCA adopted a similar thing for amending your bylaws. or you're amending your governing documents. But the court said, no, that's not what the statute says. So the regulation can't engraft that requirement on top, right? So it's a little confusing. I don't think it's a big issue for us. I think the highlights for us today is that the two issues of the executive session, you can vote, and the requirement with respect to minority affordable housing, low and moderate income housing, do not get to vote for a designated seat on the board anymore. They are huge issues in the community association. I think Greenbaum Rowe did a great job on this. Both Estes and Patel did a great job, and we're thankful of that. We would like some of the other regulations to be tweaked somewhat, but they did not make it happen in that regard. Just so you know, not surprisingly, government tends to be deferential to government. And what you're seeing at the federal level, I don't know if anyone's paid attention to this recently. At the federal level, this is becoming a very, very hot topic because Justice Kavanaugh, this is not a Republican, Democrat issue. It's not politics, but I'm sure there's some politics in it. But Justice Kavanaugh, among others, has indicated that he has not super in favor of allowing administrative agencies go crazy and write all kinds of regulation that are outside the scope of what Congress has authorized them to do, right? So we're going to see this not only in New Jersey, like this case today, we're going to see this very much at the federal level coming up because the Supreme Court has changed on a lot of issues, but it is changing somewhat on this issue. And what you've heard, many of you may have heard of this term, often pejoratively, the administrative state or the administrative branch of government. People say there's three branches of government, and they'll say, no, there's this other branch of government called the administrative branch of government. And that's what they're referring to, the regulatory state, where these administrative agencies at the federal level have undertaken things outside the scope of the Congress's legislation. So you're going to see at the federal level, especially Justice Kavanaugh, us lawyers like to kind of geek out on this stuff a little bit and think about it a little more. Hopefully the rest of you can just live your life and you don't have to think about Justice Kavanaugh. But all of us these days, we see the Supreme Court on TV more often. So that's, representative democracy demands this kind of process. And it's great that CAI did this. The exceptions, right, are narrowly tailored to balance the competing interests of the various governmental entities and of the regulations and the statute itself. And as I said before, they're mandating open meeting votes are just as to the things outside of those four exceptions. So we don't really have any questions today. I'm going to repeat myself if I keep talking. So we'll have some questions. You want to put the questions?
There's a couple questions here. The first one from Jim. If an affordable unit owner was elected last year to a 2-year term by a separate affordable only ballot, will this change? With this change, will that person need to run again this year to fill the remaining term for that seat? Right. I think the answer to that is no. So the court didn't specifically say that we're not permitted to assign a seat to an affordable owner. What they said is that you're no longer obligated to do so. So you don't need to go back and change decisions previously made. As Fran had mentioned, I had dealt with this twice in this past week, where the elections were held and the affordable owner issue was there was some framework in the regulations originally before this court decision, but they never really explained how it works. And it's always been a disaster trying to send out the proper ballots to the affordable owners and so on and so forth. So now we're no longer obligated to do it. You certainly do not need to go back and change. I don't know if you have any other thoughts on that, Fran.
No, I think that makes sense. That if somebody was elected to the board, they're elected to the board under the regulation at the time that it existed, and there's no retroactive application. So Claire here has, hi Claire, thanks. Claire's thinking about mulch still. I haven't seen any additional information on the mulch. Is there any update on the changes to the fire code, especially concerning mulch? I have not. And honestly, I haven't gotten into that. I will revisit it though. If you all would like me to revisit, I'll touch base and see if if we can do that. And so here's the follow-up question is, so voting for liens and lawsuits are no longer necessary in open session. So yes, I don't know of any associations, honestly, who started doing that. I don't think any of the ones that we were working with did. I mean, they were, many of the associations we work with were cognizant of the challenges to these regulations, and they had not started voting on things like employee issues, personnel issues, collection issues, et cetera, in a public meeting. So I think the answer to that would be no, you would not vote on your liens anymore if you're doing that already. Go ahead, Mike.
Frank, could I just make a quick comment about the mulch issue? I just happened to look it up this week, so it's kind of fresh in my mind. So the DCA, we had reached out to them and they got back to us as to whether or not it pertains. So if you recall, the fire code was amended and it states that you are no longer permitted to have mulch within 18 inches of a multifamily dwelling. It was confirmed by the DCA that does not apply to single family homes and it does not apply to clubhouses, but rather residential attached homes. So condo associations, the condo buildings, townhomes, that is what it would pertain to. No mulch within 18 inches of the structure.
Okay. Regarding, did I skip one there, Mike? Regarding running candidates?
Yeah, there's one before that. At the LAC program yesterday, they said we no longer needed to include a sample ballot with our election packages. Is this correct?
So I have to defer on that because I believe if that came up, and I'm sure if they said it yesterday at the LAC, it was correct. That was not a part of this litigation in terms of the election of the actual election package, but it may have been addressed. So again, take a step back. When I had said that CAI had first filed the lawsuit and the court said the decision is dismissed, you must go the administrative route first and then come back to us as judges if you want to later. When CAI went back to the administrative route, during that process, the DCA adopted certain amendments to the Radburn regulations. So minor amendments to the Radburn regulations were made during that process. And I will check this and let you know on this in terms of an update. But if Flack said it yesterday, I'm sure it's true. And I think I did speak about this one other time when I was talking about the administrative amendments made during that process. But as I said, I would defer to LAC on that, but I think it was during the process of the administrative amendments. So like I said, DCA backed off on some issues and said, we will amend some things on our own without having to go back to court. So if that happened, I believe it happened during that part of the process, but I will follow up for that. Go ahead, Mike.
The next comment says, this is regarding writing candidates. Does the board get to vote on whether the writing candidate can be seated on the board? I was under the impression that if there was a writing candidate, they were on the board as long as they were in good standing. And yes, Vicky, I agree. So if somebody is elected to the board with their name listed on the ballot when the ballot goes out, or if they receive the highest number of votes as a writing candidate, they would be elected to the board, and the board would not have discretion to disallow that person as long as they're in good standing.
So yeah, let me just throw a comment out there. It's a never-ending battle for free and fair elections and transparency. I hate to say that, but this kind of question, and I know it's a good question, Vicky, is exactly what Radburn law and Radburn regulation grew out of. The Radburn community, and most of you have heard me say this 1,000 times by now, but the Radburn community up in North Jersey was a community run by a board who basically had a stranglehold on the entire election process. And they would basically not allow people to run for the board unless it was their person. They would not allow them to be elected unless it was their person. And that's how we got this legislation, because we had an association that was doing the wrong thing for a long, long time. And there was not a remedy through the courts. And the court said, we can't give you a remedy, but you can go back to the legislature and have the law changed. So that was really the essence of Radburn. And certainly we don't want to see people backpedaling by adopting their own association rules and regulations saying that, oh, a writing candidate has to be thereafter approved by the board. No way. No way.
No, but along those same lines, friend, there's just another comment, which I'll just read right now. It says, but what if the writing candidate does not want to serve?
Well, so, right, that's a different thing. That's called slavery. And slavery was outlawed a long time ago. And although many of you may feel like you are indentured servants for your community, even though you're just volunteers, no, you can't compel someone to serve. You can't compel someone to serve. I'd have to look at the option. So there's an issue there, right? So if somebody is a write-in winner, especially if they had no idea that they were going to be written in, what happens? Do you take do you take the next highest vote getter? Maybe. Do you have to have another election for that seat? I think that there's a decent argument for having another election for that seat, not just taking the next vote getter. And the reason I say that is, if lots of people vote for the write-in candidate, they may not like the next lowest candidate on the ballot at all. And they might never have voted for that person, and they may have instead voted for somebody two tiers down, if they had known that the write-in candidate was going to deny. So it gets very knotty. I would have to look at the specific issue if I had it in front of me. Yeah, go ahead, Mike.
Um, all right. So the next question from Mike Polito says, I hear the New Jersey House Bill A2271 is back on the docket. This bill will affect age restriction communities. Do you have any input?
My input is, I like to think I'm smart, but if I could memorize every assembly bill, I would be a genius. And I was retired long ago with my friend Elon Musk. But I'm not as smart as Elon Musk. So Mike, I appreciate it. If you want to put some more flesh on that bone, I can talk about it, or I can even, if you want me to talk about that as a topic, I can. I just don't know the assembly bills off the top of my head. I will say that before this case came down, and this is why, I wanted to address this case right away, especially those 2 points in the case. But I had previously wanted to talk about a law that has already passed. It's a law involving foreclosures, and I'll talk about this next month. It's a law about foreclosures, primarily mortgage foreclosures, where if a home is foreclosed inside a community, the local fair housing administrative agency can bid in at the foreclosure based on a right of first refusal at the lowest number acceptable to the mortgage company, which is called the upset price, and can turn that home into an affordable housing unit. Right. So that is a little scary. I'm not trying to scare anybody, but Mike highlighted, hey, there's some other legislation out there. What was on my docket for today was I was going to talk about that foreclosure law, which is already a law that people don't even realize is on the books. But back to Mike's question for a second, I will look up at that assembly bill and I'll update you on that as well.
From Madeline says, what is in good standing? What's the definition? I'll briefly go through this. So there's what always used to be good standing was you were current with all of your assessments, monthly assessments, special assessments, late fees, fines, attorney's fees, any other charges on the account. The DCA, actually the Radburn law had changed that. And now the definition is you are current with all of your assessments, or you are challenging your assessments on your account through ADR or through or in the court. Or the third would be whether if you're current in a payment plan that's been approved by the board, then you're also in good standing, only for the purposes of voting. So when it comes to whether or not somebody's in good standing to use the pool or to access the residents only gate to get into the community, that definition you can defer back to what your governing documents say. You can actually have two separate definitions, but when it comes to voting, it's current with your assessments or challenging an ADR in court, or current with a payment plan.
Okay, so let's see. So I think I'm hitting the next one. So Ken says, hey, New Jersey Assembly Bill A2271 is a partisan bill that requires age-restricted communities to permit dwelling owners to transfer property without regard to the buyer's age. The bill's purpose is to prevent common interest community associations from unnecessarily restricting who owners may sell their homes to. So I'd have to look at the bill, but I'll comment on the topic for a second. So we have never, as a firm, rendered an opinion that says you may not purchase the property. because of age restriction. The age restriction that we always talk about is the Federal Fair Housing Act age restriction, which requires residency by one person, 55 or older, generally speaking, for the safe harbor. And most association governing documents, most of you on the call with us today, your documents require 100% of the community to have at least one person 55 or older. Even though the HUD regulations and statutes say 80%, your associations say all residences do. But to qualify for the safe harbor, it's 80%. I have not been involved, I don't believe, in any associations where they regulate transfer. And I would say, and I don't know if there's a case on this. There may be a case out of this. There may be a case on this. I feel like back in the back of my mind, there may have been a case in Manchester Township where this kind of regulation was upheld. But I don't remember seeing. I'd have to look back in my records on that. We have never taken the position that it's a restriction on transfer. It's a restriction on residency under the Fair Housing Act. Go ahead, Mike.
The next question says, is a property owner who is involved with current litigation with the board or the association eligible to run for the board? The brief answer is, as long as they are in good standing, the answer is yes. They can run for the board, they can be elected to the board, they can serve on the board. However, when the board talks about the litigation with that particular board member, then that board member would need to be recused from any of those discussions, but otherwise they'd be permitted to run and serve on the board.
Okay. In addition to elections, does the definition of good standing apply to amendments to bylaws and master deeds? You know, I'd have to check that. You guys are asking really good detailed questions today that that I haven't looked at in a while, but there is a distinction in the reg between good standing for the purposes of voting an election and good standing for other things. So I would have to check that, Jim. I don't want to give you wrong information. Go ahead.
Yep, Claire asked the last question here. It says, I understand that ADR must be rewritten concerning good standing. Sounds to be that one cannot ask for ADR if not in good standing in order to vote. Is that a yes or no?
Yeah, Claire. So sometimes there are some lawyers out there that disagree with this, but you can always ask for ADR. You can always ask for ADR. And if as Mike said earlier, I don't want to repeat entirely what Mike said, but if you're contesting a debt, right? You're saying, hey, I'm contesting a debt. I want ADR regarding this debt. I don't owe the debt. The debt's improper, whatever the issue is. You are, by definition that Mike cited, you are in good standing and can vote. There are people who disagree with that, but the fact of the matter is, if you're contesting whatever makes you in bad standing, the arrearages, etc., you're still able to vote. Okay. All right. We're at 4:39. I hope, like I said, the main message today was those two things, the executive session meetings and the affordable housing issues. And I want to make sure everyone has a great March. Happy spring. Next time I'll see you in April, and hopefully the weather will be that much better. It's good to see everyone, and have a fantastic weekend. Thanks again for attending. I really appreciate every one of you coming every month. We really do. Thanks again.